Oh, ladies and gentlemen, good afternoon. Did you hear that long speech I had? Well, the sound wasn't on. We're gonna start it all over again. Good afternoon, good evening, depending upon where you are around the world. Yesterday was a nail-biting experience waiting for Judge Scott McAfee to deliver his ruling. And yes, we had the ruling. We got it at probably about 5 minutes after the judge dropped it. I had literally pulled up to the courthouse because I was going in to cover the YSL trial, and that was the other case that we were monitoring because we knew the judge was going to give it this some type of decision, which he did. Uh, Another thing I was watching is as part of the media pool, we have a 6 month rotation for the camera people that are shooting. I'm one of the people that are shooting the trial. The extension expired on the 14th. We didn't have a signed extension by the judge. So I was wondering whether or not the judge was going the other direction. Well, the judge signed it, but he signed it yesterday. He didn't sign it on the 14th, which we all, us and the members of the media who are actually shooting the trial, thought he was going to sign it early on. He didn't. So we couldn't glean much from that other than saying, well, this judge is kind of dragging his feet. Well, he had a reason. He wasn't doing anything premature. He was actually waiting to get all the facts as he knew it and was ready to render his decision. Well, today we're going to be joined by my co-host, attorney, former prosecutor Thelma Anderson. You know Thelma. She comes in with that great spirit. But Thelma, come on up here, Thelma. Come on up here. I see you taking a little. Well, I see you doing a little nibbling on something. I don't know what you're nibbling on, but
I'm
share some
hungry.
with me. What's going on?
I'm hungry.
You're hungry.
Yeah, Big Mama is
What's
hungry.
going on? What's going on? The lighting looks good.
Yeah.
Listen, you and I called it. We right now
Let
we
me
have a
fix
collection
my wig.
agency.
Hold on, my wig.
Well, hold on. We'll get to that. I fixed mine already. We have a collection agency looking for an attorney right now to get a collection on that little friendly bat. That
Yeah,
friendly bat.
because
I sent that person the link as well. She can come up here. She got the link. She know what it is. She was certain that she was going to beat the OG out and the young G, but it
well,
didn't happen that
listen,
way. It didn't happen that way. Judge Scott McAfee delivered his decision, a very explosive decision, I may add. And we can't make light of the things he said in that decision. While ruling for District Attorney Fani Willis, he did deliver um, a blistering message to her as well. I would say that based on his ruling, he kind of let her know. Listen, you might be out of the out of the fire, but it still may be some problems that you might be looking at.
yeah,
Can we agree with that?
absolutely. He gave her, he threw her a bone, and she
Through
picked it up, and they ate it.
her bone, a big one.
A big one, because a judge can do what a judge wants to do. Um, and because this judge is very knowledgeable about the law, he's very, very good in that area. He decided to give her a warning. And a lot of judges don't have to do that. But I think because he's a former prosecutor and because he worked under her administration, he did her a big one with that, which to me it gave him even more points from me with how he handled this whole process.
Well, while he gave her an opportunity to recover from the public. I tell you, the public scrutiny was really bad, and and for for many, she still has to do some a PR campaign to clean up her image because the way they try to yes, the way she was being dogged out, the way, and he said it. We're gonna read the judge's
Yeah.
ruling, so we not make light of the fact that it wasn't just a complete victory, but there were some things that had to be done. And one of those things was that she would have to either get rid of Nathan Wade, which he gave his resignation around 2 o'clock yesterday, or she would have to get rid of the case altogether. Well, she decided to get rid of Nathan Wade, and according to my sources, she's going to be prosecuting this case.
But here's the thing,
That's
because
hold on, Thelma. That's breaking news. We don't make light of breaking news.
but we called that yesterday also. We called that yesterday.
No, what I'm saying, she's going to be the lead prosecutor in the courtroom. She's not bringing in a special prosecutor.
But we talked about that. We called that yesterday. We said that they poked the bear, and this is the person that they didn't want. They shouldn't have poked her because this is not who you want to go up against on this kind of case. So we anticipated that this would have been the move based off of just the overall sentiment of that ruling. And also we what else did I mean, it's to be expected.
Well, and we got to delve into that, and that's it's very important for people to understand. She could have referred this case or deferred this case to one of her underlings or prosecutors, but it's important for her to get inside that courtroom and let the people who have elected her to show the American people why she's prosecuting this case.
Yeah.
And that's the significant part of the ruling for me, and how she's going to handle this is that she's not hiding behind closed doors. She's coming out. No different than she came out to argue the revocation hearing for Mr. Floyd early on, but now she's going to have to go toe-to-toe with the former president in the courtroom.
Here's the thing. That's her PR right there. That's her PR right there. But also, I believe that based off of the strategy that her and Wade went in with, they anticipated that this was going to be the end all for him. What they were merely trying to make sure was that she didn't get disqualified. They anticipated that when you know a certain kind of judge, and you know that a judge you have two types of judges that know the law and judges that don't give a damn about the law. They just there because they got elected and they just doing their thing. Because a lot of judges oftentimes get elected without actually trying cases. Yes, that is America.
Because so what you're saying to me right now is that that wasn't the strategy from the beginning.
No,
that wasn't the strategy from the beginning.
But I said they anticipated. So when you are dealing with cases like this or situations like this, you have to anticipate the outcome. And if you go in anticipating outcomes from multiple different lenses, you know how to prepare effectively for your argument. So this wasn't a shock to them when the judge made that suggestion, because they had already anticipated that this may be the likelihood of him having to be removed. So when he has to be removed, then who else are you going to take over this case? Because Wade has been doing a phenomenal job in the prosecution or the buildup of this case. So the next best person would be her, because she has all the details, all the intricate parts, and she has experience with trying these kind of cases.
Okay, so let's look at this document here. Let's take a look at the latest order here. Let's go right here.
I don't know. My wig is looking a little shifty.
We are live, and people are not caring about your wig right now. We are live, and people are not really caring about the wig right now. Let's look at the order, counsel.
Oh, somebody said I was cute. Hey, I'm cute. Thank you. Okay, I'm done.
Okay, let's look at the order. Do you want to take the crack at the first page? I can do it. The first page is up to you.
I'll take it. On January 8th, 2024, defendant Roman filed a motion to dismiss the indictment and disqualify the Fulton County District Attorney's Office 8 co-defendants later joined and supplemented the motion, raising additional grounds for disqualification. Among other allegations of disqualifying conduct, the defendant contends that the district attorney obtained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney Nathan Wade, whom she personally hired to lead the state's prosecution team. More specifically, the defendant Roman alleges that the district attorney and Wade traveled together on multiple vacations, with Wade covering many of the associated expenses. Defendant Roman later supplemented his motion with receipts from some of these travels. The state responded with an affidavit arguing that the district attorney has not received any financial benefit through her relationship with Wade, and that their personal travel expenses were roughly divided equally. As alleged, the claims presented a possible financial conflict of interest for the district attorney. Most importantly, the defense motion and the state's response created a conflict in the evidence that could only be resolved through an evidentiary hearing, and one that could not simply be ignored without endangering a criminally accused constitutional right to procedural due process.
Hold it right there. Hold it right there. So that is important, because that line right there is important, because many people were saying that the judge should not even entertain the hearing, but it was very important, because you have all these defendants that saying, "Hey, listen, we want a fair trial." So the judge is covering himself and explaining to the American people why that hearing was important.
Yeah. After receiving 2.5 days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster. That muster is so like new terms that I like that. The court finds that the defendants failed. Let me say that again. The court finds that the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travel with the lead prosecutor. The other alleged grounds for disqualification, including forensic misconduct, are also denied.
So basically, all that money talk, judge wasn't feeling it at all.
Yeah, the judge wasn't feeling it. Like, find something else. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team. Now, be mindful, these are trigger words. These trigger words mean something.
Oh, now, I see where he's going.
Yeah, an appearance that must be removed through the state selection of one or two options. This is the bone that I said he threw to her, which he did not have to. The defendant's motions are therefore granted in part. You want to take on?
Actual conflict of interest. Our highest courts consistently remind us that prosecutors are held to a unique and exacting professional standard in light of their public responsibility and their power. Every newly minted prosecutor should be instilled with the notion that she seeks justice over convictions and that she may strike hard blows but never foul ones. Ooh, you must be a baseball fan. Most importantly, prosecutors are expected to assume a role beyond a mere advocate for the one side and must make decisions in the public's interest, not their own personal or political interests. Little shade there. Recognizing these are not empty slogans nor toothless admonitions without practical effect, Georgia courts have not hesitated to step in and use their inherent authority to disqualify a state prosecutor when required, especially when that prosecutor labors under an actual conflict of interest. Let's see here. He cites case law. Okay. Okay. How far should I go down? A lot of quote citations. Should I read the whole citation?
No.
Disqualifications of a prosecutor due to a conflict of interest is thus not a creature of statute so much as it is a judicial remedy recognized by our appellate courts since their formation. Generally, next page, on grounds of public policy, as he administration of the law should be free from all temptations and suspicion, so far as human agency is capable of accomplishing that object. It should be objective, right? Object.
Yeah.
Okay. That was a typo, isn't it?
Yeah.
Okay. Let's see here. Where we at? The Georgia Supreme Court has most recently denoted conflicts of interest and forensic misconduct as two generally recognized grounds for disqualification. He cites the case. A conflict of interest includes acquiring a personal interest or stake in the defendant's conviction, or seemingly incapably between one's private interest and one's public or fiduciary duties. In such circumstances, no showing of prejudice by a defendant is required. And that's important because they didn't meet that burden. Go ahead, Counselor. Page 5.
This is so because the prosecutor's duty to the public creates an additional public interest that must remain unconflicted in every criminal case. A determination of whether a prosecutor laboring under a conflict is a fact-driven one. He cites a case with a footnote, finding insufficient evidence of a conflict of interest after establishing through testimony to attenuated nature of the connection between lead prosecutor and victim's mother who worked as an employee at the same office. Okay, I see where he was going with that. In this case, Wade's manner of payment is not actionable on its own. Whenever a private attorney like Wade is paid by billable hour, paid by the billable hour, a motive exists to extend or prolong the assignment. This, however, is a tension that the legal profession has long accepted. It is also the type of speculative status violation that our courts have regularly denied as insufficient grounds for disqualification, absent silent proof or some other conduct. Thus, Wade's oath of office, in combination with the supervision theoretically provided by a neutral and detached district attorney, should generally be sufficient to dispel the appearance of any of that improper incentive. Nor would a romantic relationship between prosecutors standing alone typically implicate disqualification, assuming neither prosecutor had the ability to pay the other as long as the relationship persisted. But in combination, as is alleged here by the defendants, a prima facie argument arises of financial enrichment and improper motivation, which inevitably and unsurprisingly invites a motion such as this. Of course it does. As to the financial allegations, the court makes the following fact finding on November 1st, 2021. A district attorney hired Wade to serve as the special prosecutor. Produced an indictment. In this case, the district attorney considered at least one other option before hiring Wade, which is very important. Extending an offer to the former governor, Roy Barnes, who declined. The contract allowed a $250 hourly rate, which is trash for all his experience, you guys. That is crumbs. A relatively low amount by Metro Atlanta standards for an attorney. You see what he just said it. With
Run me
Wade's
that real money.
with Wade's years of service. I told y'all that is crumbs. That is nothing. Its attorneys charging $6.50 an hour. Mm-hmm. And contained
If
a
you can
ceiling.
get it.
Yeah, and contained a ceiling on the maximum number of hours permitted. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicate Wade ever received permission to exceed the monthly hourly cap. His contract was renewed on November 15, 2022, and again June 12th, 2023.
Hold it right there. So what the defense screwed up and didn't do was ask for any records showing that he requested to have those 60 hours extended beyond the
That's
the
important.
agreement. They couldn't find that, so the judge said, "Hey, we don't know if that happened." The judge didn't know if that happened or not, and they
Yeah.
never produced any evidence to show that he just kept on billing.
Yeah. 60 hours a month is, and for $250 an hour, trash. Between October 2022 and May 2023, the district attorney and Wade traveled together on 4 occasions that resulted in documentable expenses. Him putting these specific dates is important because we have witnesses that are stating they were together prior to 2022. The first included an extended trip in October 2022. October 2022. To Miami and Aruba and a cruise. Wade initially covered expenses for the October 2022 trip totaling approximately $5,223. In December 2022, the two flew to Miami for another cruise for which the district attorney paid $13.94 for plane tickets while Wade purchased passage for the cruise along with other vacation-related expenses totaling $36.84. The two traveled to Belize, where Wade covered resort and restaurant expenses in the amount approximately $3,000. In May 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides, the amount totaling $28.29. In addition to the two described taking a number of day-long trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. They also admitted to dining on multiple occasions and taking turns covering the bill with seemingly full access to Wade's primary credit card. So you can take over.
Okay. The defendant did not produce evidence of any further documentable expenses or gifts, nor were any revealed through the testimony. In total, defendants point to an aggregate documented benefit of at most approximately $12,000 to $15,000 in the district attorney's favor. Woo! The district attorney and Wade testified that these expenditures were not meant as gifts and not that designed to benefit the district attorney. Both testified that the district attorney regularly reimbursed Wade in cash. That cash. And if not reimbursed, the district attorney covered a comparable related expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000, and that she gave him that cash money for both cruises. She further claimed that she reimbursed Wade for the entirety of the Belize trip and that she paid for the Napa Valley excursions. And we know that to be true because they had a witness who came out and was seen on CNN talking about she paid cash in the Napa Valley. Finally, while Wade could have bought meals in 2020, which totaled more than $100, she also regularly paid for his meals. Boy, man. She was paying. How many of you ladies out there would pay like that? Put a 1 in the chat if you're gonna be are you going to be paying like Fani was paying? Put a 1 in the chat. I want to see how many people paying like Fani's paying. Let me see here. Let me see how many ladies will pay like Fani paying. Hold on. See, I seem to see no. Sonia, don't play. Sonia, don't play. Sonia, I need to see receipts, Sonia. Fair exchange is not a swindle. See, all y'all just putting that 1 in the chat. I need to see I need to talk to your other half, and they need to tell me that is a fact. Sonia, I don't know, Sonia. You did that too quick, Sonia. Okay, here we go. Such a reimbursement practice may be unusual, and the lack of any documentary corroboration understandably concerning. The judge said, "Hey, this sounds kind of sketchy because it's not normal, but yet the testimony withstood direct contradiction, was corroborated by other evidence. For example, her payment of airfare for two on the 2022 Miami trip, and was not so incredibly as to the inherently unbelievable." Well, judge said, "Well, she did call for some money in Miami, and she used the card, so it's probably, it makes sense. However, as the district attorney herself acknowledged, no ledger exists. Man, you got to follow the money. Other than a best guesstimate, there is no way to be certain that expenses were split completely evenly, and the district attorney may well have received a net benefit of several $100s. You notice he said several hundred. He didn't say thousand. That was important. Several hundred. If we are to believe, like the judges to believe, that things were done in cash. Despite this, after considering all the surrounding circumstances, the court finds that the evidence did not establish the district attorney's receipts of a material financial benefit as a result of her decision to hire and engage in a romantic relationship. So they weren't buying all the money talk, and judge wasn't buying all the defense's money talk about her enriching herself by way of hiring Wade, which is important with Wade. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was or currently remains greatly and peculiarly interested in the prosecution. And that's important as well, because we heard Ashley Merchant tell senators that Fani Willis, Madam DA, would benefit by dragging the case for years. However, in her client's situation, Special Prosecutor Wade wanted to offer him a plea deal. That ship has left. Do you think he's getting a plea deal now?
Absolutely not.
The judge is going to have to ultimately, they're going to make recommendations if they're convicted, and the judge is going to, he's going to watch this case very carefully. I don't think this is going to be a case where you're going to be able to get revenge on those who were challenging you, but we'll see.
The revenge is the fact that their clients don't get the deals that they could have gotten if their attorneys wasn't irresponsible. That's the revenge. That
is true. So this was a miscalculation by Ashley Merchant, and I would love to have been a fly on the wall when she got the ruling as well. Oh, I would have loved to be.
She's so delusional. She was so delusional in her presentation. She couldn't accept the fact that these two individuals played her at her own game.
Yeah.
They did a whole they didn't do just a reverse Uno. They did a double reverse Uno. And a skip, and then they reversed her ass again.
Okay. I don't know if I want to read all 20. I don't want to read all 23 pages. You want to read all 23 pages?
Absolutely not.
Absolutely not. Do you guys want us to read all 23 pages? Because this is a lot here. The judge said a lot. I think I'm just going to post the docs on the website. Came off as a play. Mr. Merchant's pissed. Well, Sonia Butler wants us to read it. Who else wants us to continue reading these documents? Go ahead. We can read it. We'll read it. We'll read it.
Is Sonia a school teacher?
No. Rose said that's the problem. You guys don't read nothing. Nothing. Listen, I know you can abbreviate nothing. I'm joking.
That ain't the problem. The problem is they reading, they still misinterpreting.
Right.
That's the problem.
Right.
Reading is not the problem. It's the misinterpretation of what you read is the problem.
Absolutely. With that said, the meat and the potatoes is Fani is on the case. Nathan is not on the case.
Mm-hmm.
The case will likely not be prosecuted until after the election. What does that mean? What does that mean? Trump better win this, or it's going to happen right afterwards. And then District Attorney Fani Willis is running for office as well. My guess is that she's going to win. She's going to win re-election.
Yeah,
because her two challenges are not that strong. I know Christian Wise. I don't know the other opponent, but I know Christian Wise.
They just wasting money running against somebody that is bulletproof at this point. In my opinion. Like, are you bored with your practice? Are you just trying to see what the process looks like? And that'd be my problem with politicians, especially in the legal profession. Y'all see that this woman is like, nobody is getting rid of her, and you will waste your money. You will waste our time listening to your position that is not even going to matter when the people go behind the polls. That'd be my biggest problem with people miscalculating the need for them to even get into a race.
Absolutely. And I think that I tell you what else that the defense has is they can appeal the judge's ruling. They can appeal the judge's ruling, and what that look like?
A quick denied.
Well, they can appeal it at a higher court.
Yeah, but it's going to be denied at every court. Every court. So you are literally your client already can't make the $350 bond, $350 million bond in New York. You still out here running up the tab. Well, your client can't even afford the judgment. Not only that, the judgment of the victim that won a civil suit as well. So they are being, it's so irresponsible, but that's what I'd be talking about with these older, unseasoned lawyers. At the point, they are like literally on dementia stage because they're so delusional.
Are you age shaming attorneys, counselors?
I am age shaming these individuals that need to be retired.
I don't know
because they're doing their clients a disservice.
I don't know how Steve Sadal will feel about that.
Well, guess what? He was the main one that I said was trash because he is.
Listen, I'm not gonna listen. I'm gonna say this on the record. I know Steve. He's not a trash attorney. He's actually one, in my opinion. I've seen, and let me just say this because I have a lot of respect for Steve. I've seen
you
Steve.
You can have respect all you want, but how he presented that case was trash. Okay. And I can say that as a practitioner myself, it was trash. And if anybody, a new attorney can come in and walk him around that courtroom because he is so unattuned with how to actually put on a case at this point in his career. That's the problem.
Well, I'm not Steve's PR team, but I will tell you, I've seen Steve win many more cases than he's lost. As a matter of fact, let me say, listen,
I don't care about that. I'm talking about an isolated situation right now.
Well, you can have all the experience.
You can have all the experience in the world, but you can get your ass kicked the way that he did on this particular hearing that was unwarranted. And the only reason why he did it was because he was trying to embarrass a Black woman. So at this point, I'm going to stand on business because at the end of the day, when you come for a Black woman, that's the wrong move to make. And he got his ass handed to him in these documents. Period and point blank.
So you think Steve just came for the black woman, not trying to zealously defend his client? You think it was just coming
He
for the
know
black
his
woman?
client is guilty.
Come on now. Come on.
He know his client is guilty. He know that they used him gossiping as privileged information, which is illegal. So yeah, absolutely. If you want to win the right way, don't go in trying to win on some illegal information, privileged information that you receive, and you think you're going to end up and win a case. Absolutely not.
Well, that was Ashley Merchant. They joined in on it.
If you're talking about integrity, they lacked integrity through this whole process. It's a point where you can be a zealous advocate for your client, but when you come into a courtroom with bullshit, then your integrity is questioned. Because you know, as a lawyer, your ethical and moral code requires that you come in and actually advocate with legal and admissible information, not inadmissible information like they did.
Okay, so with that said, I would just say that Steve had a different approach to his argument to the judge, and he won by getting several of the charges dismissed. He won by that.
Those charges mean nothing to RICO. RICO is the highest charge. Solicitation, who gives a damn? Because all that evidence still comes in. Who gives a damn? The information, the evidence still comes in. He didn't get the evidence excluded. RICO is the highest charge. He didn't get that dismissed. So who cares that the state now can focus solely on the RICO counts instead of having to prove solicitation? And what the judge actually said is, and this is what happens in the language in indictments. Sometimes the language is off. And that's exactly what the judge said, that they need to go back in, read the language, and then you can think about resubmitting it. He didn't say that they didn't have a case. He just said the language does not fit the elements.
Right. So it was a defective indictment.
And that's not a win. That's not a win because the state gets the opportunity to go in and reindict and fix the defectiveness.
But it still was a defective indictment.
It still is not a win. It happens each and every day in the courtroom. I've had situations where my intake attorney had a defective indictment. Guess what? We go and amend indictment and the judge approves it. Period.
Order on the defendant's special demur. That's what the order is basically. The defendant's challenge to counts 2, 5, 6, 23, 28, and 38 of the indictment by way of a special demur. Demurs provide a means for a criminally accused to ensure that the state's charging documents satisfy the constitutional mandate of the due process and the Sixth Amendment. Be informed of the nature of and cause of the accusation. Okay, that's case law. So the pre-trial, a charging document is expected to be perfect in form, as well as this document wasn't perfect in form. Thelma, it wasn't perfect in form. Hold on. In substance, the challenge language of an indictment should be interpreted literally in favor of the state, with any objection strictly construed against the defendant. Despite this, a pretrial challenge does not require a showing of prejudice, and the trial court should examine the indictment from the perspective that the accused is innocent, lacking knowledge of any incriminating facts alleged by the state. So Nathan Wade screwed up the indictment. That's what happened. Would you agree?
And guess what? It doesn't matter because it can get reindicted.
Okay.
It does not matter. And that's what you are putting emphasis on, something that can be reindicted. And because individuals,
but it was $600,000 plus spent to get this indictment.
Hold on. It takes nothing to go in and reindict other than pulling in what he could have done was amended it. That is a simple fix. So it's not a win. When you can be reindicted, it's not a win. it's a waste of time, yes, but it's not a win.
Don't you believe that the notion of chiseling away at the indictment from the beginning is always a win, because you're chiseling away at a document that you can still continue to chisel away at? We don't know if they're going to re-indict. We don't know. We don't know where this case is going to go. But the indictment was imperfect, and it should have been.
It happens. It happens. You act like this is something that is not uncommon. It happens in every courtroom around the country each and every day. The criminal justice system is not perfect. Lawyers, just like we talk about doctors practice medicine. It's the practice of medicine. They are not considered an automatic killer. Lawyers, this is the profession of practicing each and every day to get better at your profession.
But hold on, counselor, hold on. This is not, you're talking RICO. You need to have the most experienced people to prosecute this case. This was one of the issues that the defense attorneys had, that Nathan Wade wasn't experienced enough to handle this case.
You saying that you need to have the most experience. Trump has the most experienced person, and he still was horrible. Experience does not matter. Like I said, these newer attorneys, these newer licensed attorneys that are 5 years and under can come in and be better than the ones that's been here for 70 years, like Trump attorney.
Listen, this age shaming is not good. It's not good.
Let me tell you something. I'm not age shaming. I am calling it how it is. These older attorneys sit here and stay in this profession far past their date of deadline to get out. And if you are talking about age shaming, I really don't care, because at the end of the day, they came for a black woman that was simply doing her job and kicking their ass at doing her job. So if age shaming is on the table, guess what? Race was on the table too. And I'm going to stand behind mine on each and every day of the week. Period.
Black power.
Black girl magic on every day and twice on Sunday.
Guys, I had to throw that in there because listen.
And we got somebody in the comments that is really upset with me.
Who is that? I don't know who's in the comments. What? You didn't have to leave the screen. What happened?
I needed to make an adjustment. Hold on. Because I need to address this person who has a hard on eggplant for me.
Road dog, you about to get it. Pause.
Talking about what have I done in my career. Practically I'm not pushing buggies around collecting tips like you are. That's what it feels like. You don't want to question my career, because I'm in and out. I've been in and out of trials, tried several cases, more than your age right now, which isn't giving maturity. It's giving that you have a hard on for a black woman that is educated and is powerful in her position and can stand on it. So when you come from me, just know I'm gonna send you back to the uterus that had you now. And they let you out for a reason, because they ain't want you there no more. So don't do that. If you want to go back to the uterus, let me know.
They said call Ike. They said call Ike. Ike, oh, we can't call yet.
We called Ike.
Yeah, let's call. Hold on. Let me call Ike. Let me call Ike. Hold on. Let me call Ike. Let's see. We'll call Ike right
Rob now. Calling a black woman a racist. How fitting. How fitting to call me a racist.
She's supposed to be up here.
What up, Dennis?
All right, we are live. I got everyone. We in the room. Say hello to everybody.
Hello, everybody.
Hi, Ike.
Hi.
Thanks.
Where you at, Ike? We been calling for you, Ike.
Golf range.
Oh, she getting some good sunny DM.
Yes, it's nice out here. You know, this is really like our second nice day in New York. We haven't had any good days, so.
I know. Listen, we had a good day yesterday, and to that point, Delma, what do you got to say to Ike?
You really are
What the Cash App?
Yeah, y'all are delusional. Y'all are delusional.
Wait, hold on. We got listen. The American people are watching. Ike.
Hold on, the phone.
Oh, the phone. She hit it with the phone. Problem with the phone issue. I can't.
No, I'm getting in the car. I'm leaving the range right now. So, the phone picked up. Can you hear me?
A few moments later.
You so silly.
You stupid. You gonna do it while I'm in the car.
Right?
Come on. I could jump on and let the people see me. I look crazy. But I don't mind. I don't care.
You got the link. We waiting for you because Road Dogg is about to start a fight in here. Road Dogg is about to start a fight. He's calling for you. I'm like, wait a minute.
Well, I don't think he want to know that he didn't call me a racist.
Who said that? Road Dogg?
Yeah, he called me a racist.
Road Dogg. Black people don't have the power to be racist. No, Road Dogg. You can't say that.
Thank you.
Road Dogg, don't do that. Road Dogg. You know that. So with that said, she's gonna call back in. She's gonna pop up. With that said, this delay, he's gotten delays. Former President Trump has gotten delays in most of the jurisdiction. We're just waiting for, MAGA is waiting for the judge in Florida to rule, Judge Cannon.
Wait, she already denied it.
When did she deny it?
The other day.
Did she really deny it?
Yeah.
Roldo said every race can be a racist. I didn't know she denied it.
Yeah.
Okay. I didn't know.
And New York, it said that they're willing to do a 30-day delay because they received like over 30,000 documents, which to me ain't gonna change anything. So New York is not going to delay it past the 30 days. So, and they're not giving him preferential treatment. What is going to be very interesting is the Supreme Court.
Well, they're considering whether or not to the immunity issue, correct?
And they need to mind their business on there too.
Well, hold on. You're not going after the 9, are you? You're not going after the 9 now. The 9. Kavanaugh, Gorsuch. Hold on. Here's the quiz right now. I don't want you typing. I don't want you Googling nothing. I need to see your hands.
No, because I'm finna respond to this. You talking about the ones that took away a woman's right to choose what the hell
we're not. But Dama, focus over here. We're not talking about the comments.
I will come for them. I will on each and every day come for the men, especially the Uncle Tom of Peter Tom. What's his name?
Clarence Thomas?
Yes, Clarence Thomas, the Uncle Tom. Because I was thinking about Peter Thomas and his lawsuits that he keep getting involved in.
Leave my guy Peter alone.
They on his ass. Peter, he can't catch a break. He going back to Jamaica. But yeah, no, like
He ain't going nowhere. Peter's been in America all his life. What are you talking about?
Huh?
Peter Thomas.
I said he gonna go back to the Caribbean so he can get his restaurants over there if they keep on messing with him over here.
Oh my God.
But yeah, I think it's gonna be interesting with what the Supreme Court decides.
Are you Googling now? She's Googling, ladies and gentlemen. She's Googling.
No, I'm texting because I have an event that I'm going to. Hence why I have my wig on.
Period. I did not know it was a wig. All this time I thought it was your real hair.
I just sit up here and said, I'm up here adjusting my wig, and you talking about your wig looks fine. Nobody's going to care about that. Now that ain't age shaming.
That's wig shaming.
Because you forgot.
Oh yeah, Ike's in here. She's in the car now. She's in the car now. Listen, type in your Cash App in the comment section. She's in the car.
Coming.
She coming. She running. I see her right there in the background. I can bring her right now. Ike, you know we talking mess. Let me just bring her on stage. Here she go.
What the hell? You know what, Dennis? You're an asshole. Let me just say that.
He is certified.
Let me say that. You're an asshole.
Certified.
You know how long I've been sitting back here while he pretends that I'm ducking? Get out of here.
Listen,
I didn't see you.
Oh, that's right. I forgot. You are blind too. That's right.
Yes,
You're
look
blind.
at the glasses.
He is blind too. Glasses don't help blind people, baby.
No, it don't.
Glasses don't help blind people. That's like you gave glasses to Stevie Wonder, wouldn't help, baby.
Right, exactly.
It
doesn't matter.
He's gonna use that Cash App so he can get LASIK surgery.
Well, he's gonna be holding his breath for that Cash App. It ain't gonna happen.
Wow.
Not happening.
Hold on.
Let's be clear on what the bet was.
If I would have won the bet, you would have made me pay. Now don't do
I
that.
love
No. You didn't win the bet. My bet was.
We won the bet.
Let's be clear. What did I say? I said the judge is gonna find. Oh, see, now you want to do the let's be clear. I said the judge is going to find that there is an appearance of impropriety. Did I not say that?
I don't remember that.
I don't remember that.
I don't remember that part.
I don't remember that either.
Well, good thing it's on video. Because we could just go back.
You said she wasn't getting disqualified. You said she wasn't getting.
So here's what I'm saying. Here's what I say. Let me finish. I said she would be disqualified because the judge would find that there is an appearance of impropriety. The judge found that there was an appearance of impropriety. What he found was that he didn't have to disqualify her to cure that appearance of impropriety. Instead, that he could just have Nathan Wade step down. But what I'm telling you that this is not the end of this. Okay? It's not the end of it. Absolutely not.
Listen, I'm not going to play word games with an attorney.
I'm a lawyer. We play. What are you talking about? I'm a lawyer. What we do is words. It's words.
Hold on.
You know what I said.
I got the text. Okay, I got your text, Thelma. This woman better have our money.
Yeah. I know he lying, Thelma, because that's all he does is lie. Every time I'm on the phone with him, he's like, I just got a text from Sam. I just got a text from Thelma. I just got a text from somebody.
Well, let me read
I said Cash App. That's all I said. I said Cash App. This man is funny.
He specializes in lying. That's what he does.
Hold on.
Thank you. Look, I had to go to the chat so I could see people say, I remember. Yeah, I did. I know what the fuck I said. I know exactly what I said.
She called her people over and said, go ahead and support my...
Oh, my God. Now I call my people. You see the hate?
This is what she was doing. She was texting
her
people.
No. Who was I texting? If I could turn my camera around... Oh, I can't turn it around so y'all can see. Y'all can see where I'm at. See it? That's the
text was sent already. Oh, Thelma, I got your text.
I'm letting the people see. I'm playing golf. I'm out here playing golf. Okay.
She's doing something productive.
My friend's not a welcher. Don't say that.
Thank you. I ain't welching. I know what I said. I know I was clear.
You said she was disqualified. We said she was.
The judge could have disqualified her. He punked out.
Thelma, is this how you handle the courtroom?
I said he was going to find there was an appearance of impropriety. That's what he found, Dennis. He found that.
What Glanville did when Beam was going off on Steele. He just let him talk.
Okay.
I got to go back and watch that. I heard that was a hot mess.
It was. It's like giving. This case is giving Tubi. Like every day is Tubi.
That's Fulton County for you.
Why did Adrian Beam point at me? He pointed at me. I'm like, yo, Adrian, hold on, player. I didn't put your call out there.
Oh, shit, I gotta go on witness protection if he pointed at you.
Yeah, no, he
Sure,
said, he
coming
looked at
for
it like
you.
the media over there put my number out there. Wait a minute, hold on. Why didn't the prosecution redact his phone number before they put it out there? No, that was Brian Steele. That was his take. Why did he redact the guy's phone number?
That was
Because he don't care.
yeah. He got what he wanted in that 2023 recording.
But here's the problem with that whole recording.
He's got no obligation to do that. That's the
But here's the problem. Detective Quinn interviewed him in 2013 and said that Young Thug was in the car. He said he was in the car. He said he was in the car.
11 years ago. You know what happens in 11 years? Memories fade. Memories are highly suggestible, right? And so I don't know how much trustworthiness. Let me go into academic mode. I don't know how much trustworthiness we can ascribe to those statements that are more than 10 years old. Even in certain statutes, the federal law says that you shouldn't even use shit that's older than 10 years, right? So I don't know how much probative value, right?
Oh, it's got probative. It's definitely it's probative, but because of what Steele did, his intent behind it. He's the one.
But I don't know, probative for the prosecution or probative for the defense.
It's definitely probative for the prosecution, but the defense introduced it. He introduced that 2013 statement in order for him to do a compare and contrast of the 2023. The same man that has been on the stand saying that he had lost his memory since 2013. But when y'all have a conversation in 2023, his memory is very much alive with different facts.
That's right.
So when he introduced that 2013, which was negligent and irresponsible on his behalf because the man was singing like a canary. The man put him every way, but in his bedroom. So it was a bad move on his behalf because he introduced it. I'm like, why would you do that?
I have to go back and watch. I'm completely lost.
Yeah, what he did yesterday was a fatal mistake for his client.
Brian Steele did this?
Yes, he did that.
Wow. But I've been saying a long time that he should just let the other guy, what's his name, the black guy.
That's what I said.
You're talking about Keith Adams.
Yes, Keith Adams. He should just let Adams do it because I think I appreciate Steele's approach, but it's not the right approach for this trial.
That's what I said.
Not the right approach. Yeah, it's not the right approach for this trial. And damn, this is not the first time he opened the door to some bullshit.
Yeah.
Yeah, it's not the first time. Yeah, that's a problem. That's a problem. Oh damn. Yeah. I'm gonna see if I can catch up this weekend.
You gotta watch it.
I gotta play catch up on so many things. Like Bishop Whitehead was found guilty.
That was
right here in New York. That was was crazy.
Yes, he was. What do you think about that?
I saw that coming. I mean, he was tried in the feds. I mean, they got like a 98% conviction rate. Come on.
And he took the stand. How about that?
Oh, I don't know what he thought.
He thought the Lord was in the room.
Right. He's a little disillusioned about.
Let's watch for a second, guys.
Able to hear the recording?
I heard it, but I still don't remember the conversation. I like that. I heard it though.
Quinn was quinning.
That was your voice, right?
I heard it.
And on January 22 of 2023, you did remember things from September 11th, 2013.
I really did. I really did. Didn't.
Do you remember on direct examination being questioned by the prosecutor? You were asked a lot of questions about a statement that you gave 6 days after September 11, 2013, which is September 17, 2013. You remember those questions?
I don't recall the conversation that happened in 2013 to anybody.
Okay. Do you remember being asked those questions?
No, sir. Which one?
about whether you said to a Detective Quinn on recording on September 17, 2013, you were asked those questions. You said, I don't recall. Do you remember all that?
Yeah, I don't recall a conversation that I had with Detective Quinn in 2013.
Okay. Well, just for a foundation, the district attorney did not ask you certain parts of that conversation. I just want to ask you and see if you remember. Do you remember telling Detective Quinn on September 17, 2013 at the Atlanta Homicide office here nearby this courthouse that you lied to the detectives when they first came and talked to you?
Here it comes.
Do you remember saying that?
I don't recall any conversation that I had with a Detective Quinn in 2013, sir.
It doesn't have to be, and I know that's a long time ago. So we don't have to use Detective Quinn. I'm just saying any detective. Do you remember?
I don't recall any conversation I had with anybody in 2013, sir.
All right. Do you recall telling Detective Quinn on the same date, September 17, 2023, that you lied to the detectives when you first spoke with them and you put your friend Big Fred as the driver of the car? And when I say the car, I'm talking about a 2004 Nissan Altima maroon color.
I don't recall that conversation, sir.
Do you remember telling Detective Quinn on September 17, 2013 that you told, at 4533, that you told a few, and I'm just not going to say it, but bull blank lies to the detectives? You remember that?
I mean, basically, y'all keep asking me, do I recall this and recall that, remember this from 2013? I don't remember that from 2013. I keep telling y'all that. That has been my statement since I got here. Your Honor.
Your Honor.
I've been telling y'all, people constantly hit me with this, keep constantly asking me this and that and third about what's going on in 2013 or whatever. I don't remember. I don't know nothing about 2013. All I can tell you is y'all got my name on a recorder, my phone number on a recorder. These people threatening me. They calling my phone. Your Honor, I almost lost my job. I got a lot going on behind this hill. I put all this behind me, sir. Everything that had going on with me, I put everything behind me and kept moving on about my life, sir. Your Honor, I can't continue to keep going on like this. I don't remember nothing for 2013, sir.
Mr. Bean, you have to answer the questions.
I'm constantly keep telling y'all.
Don't fucking remember. What is his problem? What is wrong with Steele at this point? I don't get it. What is his
I'm going to ask you because I have to lay a foundation. Do you remember telling Detective Quinn on September 17, 2013 on recording that you add a little more hype when you speak with your wife and them from the jail, that you lied to them?
I remember y'all trying to assassinate me right now in 2024. That's what I remember. That's what I remember. All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on. Your Honor, am I on trial, Your Honor?
He played the
Sir,
piano.
you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you are not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come get me. Y'all don't threaten to lock me up. Hey, I got a family too. I mean, come on, y'all. I told y'all I don't remember that from 2013. Come with these conversations. Hey, remember we was in front of the house? Conversation we had in front of the house before we went to the Kroger?
Yeah, what was that conversation?
With yourself.
I can't hear you, Mr. Bean. Can you take your mask off if you wouldn't mind?
Keep it 100 with yourself, not me. We had a conversation in front of the house.
Yeah.
Before we went to the Kroger.
Yeah. You asked to go to the Kroger.
I never agreed to do none of this from the beginning. Before we even had this, what you just played.
Mr. Bean.
I keep telling y'all, I remember that for 2013. I didn't really remember that then.
Mr. Bean, who threatened to lock you up?
Sir, I talked to Your Honor. Your Honor, tell you something.
Look at the prosecution.
Sir, answer.
Am I on trial for anything? Can I be excused, Your Honor, for anything or something? Because I really don't understand what's going on. I don't remember. My head hurt. They keep asking me questions about this, keep asking me questions about that. About 2013, I don't remember.
No, you can't be excused at this point in time, Mr. B. You have to be, you're subject to examination.
Judge about to snap on him now.
So,
I don't remember.
Who you just told the jury, the Honorable Judge Glanville, and all of us, that you've been threatened to be locked
I
up.
didn't consent to come get on this stand to be a witness, first of all.
Who threatened you to lock you? Lock you up means go to
There
jail.
wasn't no threat. The subpoena go out. They say you don't show up, they're gonna lock you up. You go to jail or whatever, and all this little extra stuff like that right there. I ain't here to point fingers at nobody, say nothing like that. That ain't my job.
You just said
It ain't for me to mention what nobody got going on in their life. I got my own problem.
who threatened you? You just told the jury that you've been
I done
threatened.
had all kind of
You shouldn't
threats,
get
man.
the
Y'all
state
just destroyed my
prosecutor.
whole phone number on to the world. People
You
calling
did
my phone right now threatening me, texting my phone. I ain't had no sleep. I've been up all night since yesterday, 7 o'clock, from 7 o'clock yesterday to 6 o'clock this morning. Still getting calls. Still getting texts. That's my personal line y'all just gave out. On live to the public, to the whole wide world.
Who threatened to put you in jail, Mr.
he's answered that question already, Mr. Steele. Let's move on from that.
Do you remember telling Detective Quinn on September 17, 2023, that when speaking on a jail recorded lines for your wife, I'm visualizing the story, trying to make it all one. You know what I'm saying? I ain't telling them a lot. A little shenanigan, be bold blank. Remember saying that?
I hate when he
The
try to
girl
read
already
shit.
asked me 1,001 questions. I told her I don't recall nothing from 2013. I don't even recall the conversation really that me and you even had.
Do
If
you-
somebody else push up on me, ask me questions, let somebody else come to. I give them a story too.
I got a
Everybody
minute.
keep
I got
asking me
a million
questions,
of
asking me questions. I'm gonna move on with my life, man. I ain't got time for these games. Y'all done assassinated me, man. Hey, it about time for some actions now.
What axis is he talking about, Ike?
Do you
I'm
remember?
all these blogs, all these channels, my face all over the news, everything like that.
They talking about you, Dennis.
People don't ask the
Yeah.
question. I'm telling you, I don't recall.
What are you doing? You trying to
Okay,
send me
well,
a
I just
signal
have
player?
to answer these
He
questions.
did.
Talking
He
about-
just sent you a
Do you
whole
recall telling Detective Quinn on September 17, 2013, that on jail calls, that you bold blanked around with your family a lot, bold blanked around with the story a lot?
Mr. Steele, for the completeness of the
Bull
record,
blanked.
you need to
Bull
say it.
blanked.
If you hate wearing bras, you should try me.
Hold on. We're gonna leave that alone. Hold on, ladies and gentlemen. We're leaving that alone. So, how would you handle an examination like that, Ike?
I don't know what came out on direct, so I'm not sure what Steele is trying to accomplish on this cross-examination. So he said he didn't remember anything when Miss Love asked him questions.
Yeah.
So I'm not sure what's the goal here, right?
Yeah.
I have no idea why you try. And he said he doesn't remember 1,000 times. So what did he introduce that was harmful?
So then,
You said he opened the door to something. What did he introduce that was harmful? Because to me, it seems like what he's trying to establish is that this guy is a liar and that he has no compunction to lie. Like he'll just lie because it's the nice day.
well, he said it himself. He said, "I'll tell someone else's story."
Exactly. That's what he was. I guess he was trying to establish. You told him that that you embellish, right? When you tell stories, you hype it up a little bit. You're hyperbolic in that sense.
So
right?
I see what Steele's trying to do. That recording that is very damaging that they played of Detective Quinn. That he's just trying to say this guy's just a lie anyway. He was good when he thought he was gonna get his own interview in and discredit the DA's the Detective Quinn's interview. I see what he's doing. He's trying to, even though it sounds believable, he wants the public and the jurors to believe that This guy's just a habitual lie. He's lying about everything.
Right.
The jail
And I
call.
think that was clear. He established that. Right? And basically, he's like, I don't remember anything. I said whatever I needed to say at the time. And, I'll do it again if I have to. I don't know what's harmful about that yet. Where's what he introduced that was harmful?
So here's the thing: when we're talking about a jury judging the credibility of a witness, and here's the issue that I have with his approach to this particular matter of trying to establish that he's not credible and he cannot be trusted. One thing that jurors pay very close attention to is how close in time the information was provided to the police. So what they're going to look at is that statement from Detective Quinn, on top of the other evidence that is being used to tie Doug to this particular offense. Now, what I think Steele did wrong was have that interview with him in 2023 and trying to use that as a way to discredit him, because he was asking very suggestive questions to lead him to say what he wanted him to say. And now we don't know the extent of the interview outside of that, which we feel like the state is going to get into based off of his response. You know what we talked about at Kroger. You know what's going on. That is a problem, in my opinion, because it is giving off witness tampering.
So you're trying to suggest
giving
that
off what?
Witness tampering. You're trying to suggest that Steele's tampering with a witness.
So, if that's the is Steele tampered, or that Quinn was tampering with the witness?
No, it's the 2023. When you listen to the 2023 call, interview that Steele had with this individual, who now says that his memory is so distorted that he could not remember anything. But during that conversation with Steele and the suggestive questions that Steele was throwing at him, outside of what he just said on the stand, you know what we talked about at Kroger. That it to me is giving that the conversation, I don't know why that happens. The conversation that happened was them trying to, get him to say what they needed him to say to throw this case.
I don't think that that's going to be the takeaway, only because, in Georgia, unlike in New York, defense attorneys have the opportunity to speak with a witness before they testify. Yeah. And they've done that with all of the witnesses. They've talked to all of them. So I'm not saying that they don't have the ability to. I'm just saying it's a complete difference from 2013 to now in 2023, when he have a conversation with Steele and is suggesting that Thug was not even a part of it. But that call that was made, this man says this was Thug's hit. Thug was in a car. Oh,
this was
he said that on.
Yes, he said that to Detective Quinn. He put Thug everywhere but in his bedroom.
Wait, so I'm confused. Wait, let me just ask this. Because we're talking about obviously different statements or different times. Because when did he tell Brian Steele that this was Thug's hit?
No, he told the detective.
Okay.
So the detective interviewed him right after this happened. And
after
so, and also the jail call that he made to his girlfriend,
his wife.
He also his wife. He also puts Thug in a car and a part of the offense. So you got
that was
different.
In 2013.
So you got two different recordings when he's talking to his wife and when he's talking to the detective that puts Thug there. But when he talks to Steele, he has a different story in 2023.
And we were able to listen to some of the recording of Detective Quinn yesterday, and it was a very, very colorful interview. Very colorful.
Was it suppressed? Was that suppressed?
No.
And what was something was suppressed, right?
That it was suppressed against the other defendant, Weinstein's client.
Okay.
Yeah.
Okay.
So this recording, which we heard about 2 hours of it, almost 2 hours of
Yeah,
it.
and they not done.
No, they're done. We come back on Monday at 3:30. Monday at 3:30, court starts.
So the
So it
issue.
doesn't sound like that's what I thought, maybe that when he was on the phone with Brian Steele, he said that was Thug's hit. And
No,
that's
no,
what
no, no. He,
harmful.
no, he didn't say it was Thug hit. The
Okay.
only thing that what I am drawing when it comes to the minds of the jury, if the jury is going to find the 2023 interview with Detective Quinn in their jail call more credible.
Not 23, 13.
No, 2013 jail call and interview with Detective Quinn more credible than the 2023 interview that Steele had with him, because at that point, what is the motive? What is the intent? But that's something the state is going to have to draw out.
I'm a guess that this is why I'm gonna think this jury's going to listen to what was said in 2013.
Yeah,
because anything can change after the fact. 10 years later, you got Thug is worth a lot. I'm not saying that people got to him. I'm just saying that people might have got to him.
Yeah, and how uncooperative he has been also. And the jury is going to look at his body language and how he has been responding to questions on the stand. And I'm like, okay, he's just here. He doesn't want to be here, so he's going to say any and everything. But we're going to draw attention back to 2013 when he literally, what did he have to lose?
I mean, yeah. I mean, he was subpoenaed. The whole line of questioning on the stand, didn't the prosecution know this guy wasn't going to give anything?
They know. So the state knows when they're going to have a hostile witness, and they knew based off of his ducking and dodging and not wanting to speak to them. None of that. They knew. They were very much prepared. That's the reason why they made sure that in the event that he didn't show up, they was gonna send the sheriffs out to wherever he was at.
Yeah. This, here's the problem I have. Even with this guy, you shielding certain people from the cameras. Like we got the list of the people who need to be shielded next week.
Why didn't he shield him?
Yeah, why didn't he shield him?
But I let me just say this. If you got to think about what a credible witness is, he doesn't seem like a credible witness. I don't know that a jury is going to say, you know what, he's believable in any respect. You know what I mean? It's like they can, and then I'm sure that you have the false in one, false in all charge, where the judge is going to instruct the jury that if you believe a person lied about a material fact, then you can reject all of their testimony, or you can accept the parts that you believe were truthful and reject the rest. Right? So
yeah,
they could pick apart his testimony and see if there's anything in there that's credible. But I think once the witness himself starts to denounce his own statement, it becomes less less probative. I think at that point it becomes less probative.
The last part of what he said on the stand, I could tell someone else's story. So that right there, this guy who said I'm just a liar.
Yeah, well, I'm going to say what I need to say to get out of whatever I need to get out of.
Mm-hmm.
I've
Even
done
that
it
witness
before.
stand. Get off that witness stand. So
right.
But they're gonna play it. They know they're gonna. He's probably gonna be non-responsive, even listening to it. The detective will come. He's the next witness they're gonna call.
Yeah, Quinn is
next.
Huh?
Mr. Sauce himself.
Yeah. They got to bring him in at this point.
They got to.
He's still on his TV show, right?
Mm-hmm.
They probably watch him too.
And
that's the guy from the TV show?
Yes.
Wow, that's Quinn?
That's Quinn.
Ain't Quinn smooth? Ain't he smooth?
Quinn's smooth now.
Right.
He's a smooth criminal. I think
it might be a treat for the jurors to actually.
Yeah,
I've seen him on a murder case before, and I've actually interviewed him at a press conference, and I can tell you, he comes across on the jury on the witness stand is very believable.
I'm sure he does.
He got all the swag. He had the swag for criminals. He had swag for the jury.
Mm-hmm.
I really hope that Brian Steele will make sure that it is Adams doing the cross on him.
And thank you.
Gotta be.
Because Steele cannot do it. He can't do it.
Gotta be. That's gonna be entertaining.
That's the showdown that we want to see. We want to see who is going to be. We ain't worried about the state and the direct because it's very direct. We want to see who is going to cross him because that is going to dictate this whole 2023 offense. Who is going to cross the main detective on this case that got that statement from Beam? Like,
it's got to be Adams. It's got to be Adams because he's the only one. First of all, he's the only one that out of all of the defense attorneys who actually understands how cross-examination works.
Oh yeah, he's been
the only one. Yes, and he's the only one who's always asking close-ended questions. I don't see Steele doing that. Steele is on cross open, asking every open-ended question you could imagine. I'm like, what the fuck is he doing?
Like,
what is he doing?
Us off. We like, sir.
Right. Well, you control your witness. Your witness should be a bobblehead doll. Yes, no, yes, no, yes, no. That's it. But he doesn't do that. You get that from Adam.
Well, Bean is helping both still, I guess, because he's not giving anything. He's the only one that you can't kind of maneuver around the courtroom.
You can, but again, it's about control.
Yeah.
All right. So even if you got a witness who's acting like that, you say, I understand. You don't want to be here, right? Let them tell you that.
Yeah.
You don't want to be here, right? All right. So I'm going to try to make this as easy as possible. All right. I just got a few questions for you. So that they know that you're not trying to attack them. This guy will give you everything he needs, and I don't think Steele recognizes that there are certain witnesses that will give you what they need. He's one of them. He just told you. I'll tell you whatever. Just get me off the fucking stand. Right? So he shouldn't have been trying to get him to commit to his memory in 2013. He didn't remember. Okay, but as you sit here now, Thug wasn't a part of that incident, right? Not that I can recall. Okay. Right? So why we gotta go
get out of there?
Yeah, get out of there. Get what you need from him.
Quinn's going to have to come in and tell the jurors why he believed that this guy was telling him the truth about Thug, because now he puts Thug in the car. So why? But Quinn, if you listen to the recording, Quinn didn't really know who Thug was at the time. He just said this guy was saying he's Lil Jeff. He said, I know his father better, which was interesting. He knows the father better than he knows Thug.
Wow.
Well, why are you in the car with the son? You're in the car with the son, but you really didn't know who he was. You didn't know him that well, but you know the father more.
Right.
So it's kind of weird that he would give that type of response to Quinn, and he might just be lying because this guy looked like he ain't gonna. I don't really think he's a good witness for anybody.
No, he's not even a good witness for himself.
No.
Right. They haven't had any good witnesses. That's the problem with this damn trial. But that's your girl. That's your girl. All right, listen, I gotta go.
All right, the other guy was
on the driveway.
All right.
I'll try to jump on later.
Hold on.
Or let me know if you want to do.
Ike, don't go yet. Hold on, Ike. Hold on, real quick. Don't go yet. All right, that's it, guys.
Broke my glasses.
I dropped a banner on the page for you, Ike.
He's so petty.
What it say? Please stop the channel. Cash it. I don't see it. I don't see the banner.
You read the whole thing. I don't see it.
Here's what I'm saying.
Listen.
Kiss my ass. How about that? Kiss my beautiful black ass. All right. All right, y'all. I'm out.
All right.
Yeah.
Bye, Ike.
I tell you, man. I tell you, am I stuck with holding the bag now?
Them New York women is something else. Baby, listen. If you want to make it through life, you better have one in your circle.
Well, Thelma, I tell you, man, it was good. I'm actually heading out to dinner. Gotta change up. I'm going to a nice Italian restaurant. I ain't gonna say
Okay,
oh,
Italian.
it's Italian.
Italian. Hmm.
I'm gonna get some mussels and lobster tail.
Mhm.
Oh,
With some Cabernet.
okay,
Get you some-
no, Merlot.
Oh, because I'm a Caymus kind of girl.
Well, neither one is Grey Goose, right?
Oh hell no. That's like Grey Goose is like, ooh, it's like gasoline.
Ooh.
That's pouring gasoline down your throat. Ain't no way.
Mm-mm.
We
I'll
didn't
still go
elevate.
sarsaparilla.
We didn't elevate it past the gasoline.
Do you know what sarsaparilla is? Does anyone in the comment section know what a sarsaparilla drink is? Anyone?
I thought that was an herb.
No Googling. What is a sarsaparilla? Real quick. You got 10 seconds. Look at you looking at your phone again. There she goes. She Googling. She's gonna look it up.
I think it's an herb.
No. A sarsaparilla
It's green.
No, it's root beer. Root beer soda. That's what it is. I know. It's okay. It's okay. Anyway, Thelma, thank you very much for coming in. And
yeah, we put the boxing gloves on.
Huh?
We put the boxing gloves on. No more age shaming from me, guys.
No more. No
more. I've learned my lesson.
Miss ATL, before I leave, you had made a reference to the other blogger. I didn't know what you were talking about. You made a reference. Oh, we're doing another show about the other blogger soon, but not right now.
What blogger?
No, you don't want none of that. You don't want to be in that. You don't want to be in that.
What? I'm nosy.
You don't want to be in that. We're gonna leave that alone right now. We're gonna leave that alone.
Okay, well tell me off the record.
Yes, I'll tell you off. I'll tell you off. Oh, it's random? Okay. All right.
Tell me off the record, because I need to know if I need to be a referee. You know.
Man, they came for Pam, they came for me, they came for a few people.
They came for you for what?
Man, they were just coming. That's one person. They were just coming for me, Pam, grown woman vibes, all the usual suspects.
Well, can we briefly talk about how I am so happy that Cardi put out such a amazing summer record for the women? Because listen, that record, I'm like, yes, Cardi, this is what we've been waiting on. This is the record that we've been waiting for you to give to us. So if this is how you coming on that album, sis, this is what we've been waiting on. And we don't need you to delay it any further. Just go ahead and give us all. We ready. We've been waiting, and it's here.
Great song. Hold on.
Yeah. So tell Cardi that we ready for the album. She done gave for the full menu now.
You like the song selection, the music selection as well?
Yeah. I like the subtle song that she came out with first, and then she hit us with, she was like, I just gave y'all appetizing. Now here go a preview of the full course. Okay. So we ready. We need it. We've been waiting on it, and we feel her energy, and we know that she is gonna give us everything that we'd asked for.
Absolutely. Thelma, thank you. Thank you, Thelma. I appreciate you. I really do. Ladies and gentlemen, make sure you like, subscribe, and be on turn your notifications on for our next live.
Yeah.
Because it's going down. It's going down. Ladies and gentlemen, we are out of here.